Welcome to the podcast, The Great Return, Decoding the Israelite Inheritance. Now, they didn't think just to steal the land. They stole the entire label. What if I told you that the Doctrine of Discovery wasn't just a law for foreigners, but a cage designed for the original inhabitants, the ones that they reclassified as black? Why did they do it? To erase a biblical inheritance, right? Today, we stop asking for permission and start auditing the title. Me, Lenora with My History Verified, is in that chair. Let's begin to decode the trust. Welcome back to The Frequency. I'm your host, Lenora, with My History Verified, and today we are stripping away the colonial veneer of American history. We aren't talking about civil rights. We are talking about indigenous sovereign title. We are diving deep into how the children of Ananya, the technicians of truth, are using the master's own legal doctrines to reclaim the vineyards of Jacob. We're examining the 2026 executive orders, the Tyrian lineage, and the backdoor strategies to protect our soil from the BIA's gatekeeping. Now let's get into the meat of this. It would be to touch on the concept of the Doctrine of Discovery, which is a critical overview of it. The Doctrine of Discovery is a framework of public international law and religious ethic that emerged during the 15th century, which is the age of discovery, to justify the seizure of non-Christian lands by European monarchs. 1. Theological and legal origins, which is the papal bulls. It means that the doctrine's foundation lies in a series of decrees from the Catholic Church, most notably Dom Diversis, which is of the 1452, and Inter Caetera 1493. These authorized Christian explorers to invade, search out, capture, vanquish, and subdue non-Christian peoples and claim their property. Terra nullius, a core concept meaning nobody's land. It was used to classify inhabited land as vacant if the inhabitants were not Christian, thereby making it available for European claim. So if somebody wasn't already here, how could they be claiming it? If they wasn't of this land, how could they today say that they are the people of here when they weren't the original people that were being booted off the land? Next is the ethnocentric superiority. The reason for this is that the doctrine promoted the narrative that European culture and religion were inherently superior, dehumanizing indigenous populations as heathens or savages who lacked legitimate property rights. Then we get into the codification in United States law. First case will be Johnson versus McIntosh, which was about 1823. Chief Justice John Marshall formally incorporated the doctrine into U.S. federal law. The Supreme Court ruled that discovery gave European nations and later the U.S. ultimate title to the land, reducing indigenous rights to a mere right of occupancy. Then there's ongoing precedent. The doctrine has been cited as recently as 2005 in City of Shuro versus Oneida Indian Nation, where Justice Ruth Bader Ginsburg utilized it to limit indigenous land claims. Then we have the related doctrines and manifestations, and they are manifest destiny, which is a 19th century American offshoot that framed westward expansion as a divinely ordained mission to spread civilization across the continent. Then we have the Monroe Doctrine, and you see that that is currently being used today within the politics and the executive orders being issued in year 2025 and 2026. That is that the Monroe Doctrine is influenced by the discovery principles. It asserted U.S. hegemony over the Western Hemisphere against European interference. Then we have the Regalian Doctrine, a parallel principle used in Spanish colonies such as the Philippines, asserting that all lands belong to the state unless title can be traced to the crown. Then we have modern repudiation, where the Vatican in March 2023, the Roman Curia, formally repudiated the Doctrine of Discovery, acknowledging it did not adequately reflect the equal dignity and rights of indigenous peoples. The denominational actions, like groups like the United Methodist Church, the Presbyterian Church of USA, the Unitarian Universalist Association, have issued formal condemnations and participated in acts of repentance. Let's remind ourselves of the specific regional impact, the Western frontier. In the American West, these doctrines converged to justify the Plain Indian Wars because indigenous hunting and gathering were not viewed as cultivating the land under discovery and manifest destiny principles. The land was often treated as effectively vacant and open for seizure by the U.S. military and speculators. I promise you that there is a method to the madness after I gather all of this research together. Now let's get into the federal trust responsibility, which is a legally enforceable fiduciary obligation under which the United States has charged itself with moral obligations of the highest responsibility to protect tribal treaty rights, lands, and resources. Now, while it originated in the Marshall Trilogy as a paternalistic guardian-ward concept, it has evolved into a complex mechanism for modern litigation. Now, that is the fiduciary standard in litigation. Let's get into modern courts. The trust responsibility is not a generalized moral duty, but a judiciary enforceable fiduciary standard. One example is specific versus general trust. The Supreme Court has clarified that a general trust relationship exists, but for a tribe to win a lawsuit for money damages or specific performance, it must point to a specific statute, treaty, or regulation that creates a conventional trust. Then we have the sovereign trustee. Unlike a private trustee, the U.S. government is a sovereign trustee. This means courts often defer to the executive and legislative branches, holding that government's duties are governed by federal law rather than the common law of private trusts. Let's get into some landmark cases. All right, so some of the landmark constraints. One, for example, is the Arizona versus Navajo Nation of 2023. It is a pivotal shift which occurred with this decision, which significantly narrowed the scope of fiduciary duty in the absence of explicit mandates. 1. No affirmative duty. The court ruled that the U.S. does not have any affirmative duty to take steps to secure water for the Navajo Nation, even if the tribe has reserved water rights, because the 1868 treaty lacked specific rights creating or duty imposing language regarding water. The impact on the litigation is that it established that the government is not required to be proactive in managing trust assets unless a law explicitly says so. A major blow to tribes everywhere. Tribes were seeking to compel federal action on resource management. Then we have modern litigation trends, like, for instance, the year 2024 through 2026. Contract support costs. In the 2024 through 2025 term, cases like Becerra versus San Carlos Apache tribe reinforced the government's duty to fund tribal health care fully, interpreting the Indian Self-Determination and Education Assistance Act, ISDEA, as a mandatory obligation rather than a discretionary one. Now, I promise you that even though these are Western tribes, many of these Western tribes began as the original chiefs of the Eastern tribes that fled west because they were either fighting with other tribes and or fleeing wars against the whoever the government was invading. It could have been the British, it could have been the Portuguese, it could have been the Spaniards on the East Coast. So we have to keep in mind that these cases are here, but they also reflect all tribes and how we can utilize precedent cases to educate ourselves on how to move forward with gaining sovereignty or gaining our identity back as indigenous individuals. All right, so we also have the erosion of sovereignty, which is a Castro-Huerta case of 2022. And this case is Oklahoma versus Castro-Huerta. The decision continues to impact litigation by allowing states' current jurisdiction on tribal lands, which critics argue undermines the federal government's exclusive protective trust role. Then we have the executive oversight of that case, and it states as of late 2025 and early 2026, tribes are increasingly filing amicus briefs to prevent the freezing of federal programs, arguing that such pauses violate the government's fundamental trust and financial obligations. Then we have the trust as the shield versus sword. The shield is actually used by the government to justify its authority over tribal affairs and to defend its actions as being in the best interest of tribes. The sword used by tribes in litigation to hold the government accountable for the mismanagement of trust funds, lands, in other words, the Cobell settlement or natural resources. Now, as you look and as you listen to all of this, and you see that it appears that there's a tribe that's fighting for its land rights, and that they are already recognized or federally recognized. You have to think about how you fit in this and how you were exchanged from all of this inheritance. Okay, the identity theft as well as the land theft. All right. So you have to tie it all in. Let's get to all of this. Now, if you're seeking to reestablish indigenous status after historical reclassification, particularly those identifying with the Israelite Tyrian lineage and claiming indigenous American origin, I promise you it's going to get all better in these podcasts. I promise you I got a lot of meat for you. The legal pathways in early 2026 are complex. These strategies must navigate a federal system that differentiates between racial identity and political tribal status. Now, you have a lot of people talking about allodial titles, land patterns, and because a person or you cannot comprehend or you're not on that level yet, you have a tendency of disregarding it, pushing yourself at the end of the line to be assisted with this. I have not been on board with allodial titles or land patterns, even though I've came across them. I knew to personally pursue them, but as a collective, I always thought it was an individual process because there are so many ancestors and there's so many documents, there's so many land violations with the 4,096 great-grands and the parents alone, not to mention their children coming down the line. All right. So first of all, you have to identify with the Israelite Tyrian lineage and claiming indigenous American origin, which is the legal pathways in early 2026, which are complex. Everybody else can claim it when they shouldn't. So what harm is it of you? We must see. Now, there are some strategies that we must navigate within the federal system that differentiates between what we call racial identity and political tribal status. Let's get into that. We have what we call the genealogical and lineal reconstruction. Now, because the BIA does not conduct research for individuals, the proof of burden rests on the claimant, which is you and I, to demonstrate descent from a recognized tribal member. What that does is reverse paper genocide. Legal strategies involve challenging historical records where ancestors were reclassified as Negro or colored. This requires negative evidence research, tracing ancestors through birth certificates, census records, and even wills where they may have been listed as property to find their original tribal affiliation before reclassification. Then we have the DAWs and historic rolls, which is for the if we direct it towards the 5 civilized tribes and others, which are the claimants who must prove lineal descent from an ancestor on the DAW's roll or other official censuses. Then we have the DNA evidence is legal limit, biological versus political. Federal law and the BIA generally do not accept DNA tests as proof of tribal citizenship. Tribal sovereignty. Individual tribes set their own membership criteria. Some may use DNA as a secondary tool to establish biological relation to an existing member, but it cannot override the lack of a paper trail to a historical role. Then we have the constitutional challenges, race versus political status. Modern litigation is increasingly focused on whether indigenous is a racial or political category. Let's start with the equal protection challenges. Recent cases argue that laws benefiting only Indians are a racial classification subject to strict scrutiny under the 14th Amendment. A case called Rice versus Cayetano is precedent. It states that in the year 2000, that the Supreme Court often cited by those challenging ancestry-based rights, as is ruled that using ancestry as a proxy for race in voting is unconstitutional. Now, reclaiming identity, reclaiming Israelite identity. For those identifying as the biblical tribe of Jacob, no current federal status recognizes this specific theological identity for a land title. A potential, though untested, constitutional strategy would involve First Amendment free exercise, combined with what? Self-identification rights under what? The UN Declaration on the Rights of Indigenous Peoples, asserting that state reclassification violated their religious and cultural continuity. Then we get into the impact of 2026 executive orders. Remember the Executive Order 14210, which was the workforce efficiency? This order prioritizes streamlining federal processes, which may inadvertently fast-track the denial of complex recognition petitions that lack standard documentation. I want you to pay attention to that. That means that your paperwork has to be on point. And even if it isn't totally, and you're giving all the best that you can with the information on those documents, submit them. Let them tell you what's wrong. Then we have the rescission of equity mandates, the removal of Executive Order 14112 in 2526, which means that federal agencies are no longer strictly mandated to harmonize their actions with tribal trust responsibilities, making it harder for unrecognized or reclassified individuals to compel BIA assistance in land disputes. So they already know that the reclassified are coming for the land. This is 2025-2026. 24/7 verification system in 2026. A new verification division launching in 2026 aims to enhance administrative support, but it may also serve as a more rigid digital gatekeeper for those whose ancestry does not match existing electronic federal records. In summary, for the reclassified Black Indigenous person, the primary legal hurdle is that the U.S. recognizes tribes as political entities, not racial ones. Reestablishing status requires bridging the gap between biological Israelite ancestry and documented tribal citizenship in a climate where federal 2026 policies are shifting toward administrative rigidity. All right. Do you know that the utilization of heirs property laws represents a sophisticated strategic pivot for reclassified indigenous families, who is the Israelitarian lineages, who have been written out of BIA protections. Because the BIA only exercises fiduciary duty over trust land held by the government for recognized tribes is what that is. Families whose lands were reclassified as private or Black-owned must use civil property law to defend their ancestral inheritance. So how do we do it? 1. Uniform Partition of Heirs Property Act, which is the UPHPA. As of early 2026, we're in January, and they're already talking about this. The Uniform Partition of Heirs Property Act has been adopted by the majority of southern states. It serves as a critical backdoor defense, preventing forced sales. Traditionally, developers would buy a small share from one disgruntled heir and force a partition by sale of the entire estate. The UPHPA mandates a right of first refusal, allowing other family members to buy out the developer's share at a fair market value. Sentimental value over market value. The act allows judges to consider sentimental and ancestral value when deciding whether to divide land physically rather than selling it. For reclassify indigenous families, this is the only legal venue where their historical connection to the soil is given weight outside of BIA recognition. Then we have the USDA heirs property relending program. Now, if you live on a farm and your family owns farm or the resources own it, you would know that the fiduciary rights would be not only the land and or the house on it, but all agriculture that grows on it, growing up into the air and going to where the actual airplanes are able to touch it. That means airbound. Fiduciary is, I can't remember if it's infinity or not. Don't quote me on it. But that's where fiduciary rights go. So when we're adding the fiduciary rights to land, and we're talking about returning land or getting land back, you have to understand that you're entitled to whatever that land produced yearly. So if someone takes that land over and they tell the government that they grew $1 million worth of oranges on the land, and they produced orange juice, and they report the cost, they report the profit from that. That's fiduciary rights. You own the land, the vegetables that grow, the raw, produce that grows on the land, the trees, the animals that help it grow. You own all of that. So we're going to continue. Let's get back into the USDA heirs property relending program. Now, the USDA heirs property relending program is being utilized in 2026 to bypass the BIA's refusal to recognize non-enrolled status. Here's how this is going to help you. Establishing clear title. This program provides loans to heirs to resolve title issues by clearing the title through the USDA rather than the BIA. Families can secure their land as fee simple property, which, while taxable, is legally shielded from the termination risk associated with federal tribal status. Then you have the resource management. Once a title is cleared via the USDA, families can assess conservation and agricultural grants to manage resources like timber and water that the BIA will otherwise restrict to recognized tribes only. Then we need to get into the Israelite cultural defense in civil court. In southern courtrooms, reclassified families are beginning to use the affidavit of ancestry combined with UPHPA protections. Genealogical preservation. Since they cannot access the BIA's Office of Trust Services, families are creating private land trusts. By placing the heir's property into a private trust, they can define membership based on Israelite lineage rather than federal blood quantum.
And welcome to my podcast with your host Lenora, better known as my history verified.